Hi, everyone, and welcome to episode 24 of Study With Me. European Union Law, this podcast helps you get ready for your university exams and gain a deeper understanding of the subject. Today, we are doing a critical deep dive. We're going right into what you might call the engine room of the EU's entire legal system.
We are. We're talking about secondary law.
Exactly. And if you're a law student, getting your head around this layer is, well, it's completely non-negotiable for passing your exams. This is where the treaties stop being abstract and start being real.
It's the functional blueprint of the Union. It really is.
So our mission today is to break all of this down. We'll look at the strict hierarchy, master that core idea, the principle of conferral, and then get into the classifications of the acts themselves.
Right. From regulations, which are immediately binding, to directives, which need that national translation step.
If you can clearly explain the relationship between primary and secondary law by the end of this, you're in a very good place.
You've understood the system's structural integrity.
Absolutely. So let's start with that foundation. We all know the treaties, the TEU, and the TFEU are the big constitutional pillars. That's primary law.
They set the goals, the competencies, the procedures, the whole framework.
So how does secondary law, this second layer, actually fit into that structure?
Well, secondary law is, by its very definition, structurally subordinated.
It's subordinate.
Subordinated to EU primary law. It's on the second level. And what's absolutely key here, the thing you have to remember, is that it derives its entire legal force from the treaties.
So if a secondary act goes against a treaty provision, say on fundamental rights or something,
It's illegal. Simple as that. It can be and will be annulled.
so it's not just subordinate, it's
entirely derivative. And that fact leads you straight to the core limitation on all EU action.
which is the principle of conferral.
Precisely. The principle of conferral dictates that the EU institutions, the Commission, Council, and Parliament, can only act within the limits of the powers explicitly given to them by the treaties.
You can think of the treaties as kind of permission slip for everything the Union does.
That's a great way to put it.
Wait, before we move on, doesn't that create a problem? I mean, the EU is trying to tackle new issues all the time, things that weren't even imagined when the treaties were written, like, I don't know, digital policy or AI.
That's a really sharp question. It gets right to the heart of that institutional balancing act.
So if the treaties don't explicitly give them competence for regulating, say, environmental noise pollution, are the institutions just stuck?
Well, the principle of conferral is the rule, but you're right, there's some built-in flexibility. The treaties do offer what are called flexibility clauses.
Okay.
Article 352 of the TFEU is the main one. It lets the Union adopt measures where powers haven't been explicitly provided, but, and this is the important part, they are necessary to achieve a treaty objective.
So there's still a link back.
Always. And even then, using those clauses requires unanimity in the Council, so it's a high bar. It just reinforces that the origin of the power always has to be traceable back to the treaties.
That is such a crucial distinction for an exam. You can just repeat this to yourself. Secondary law must respect the principle of conferral, meaning it is limited by the powers granted in the treaties.
Exactly. It's the check against mission creep.
Okay, so we know where secondary law stands. Now let's look inside the category itself, because it's not just one big block. It's organized into, well, a few different classifications.
Right. The sources give us a few different ways to slice this up. The first and most important grouping are what we call the codified acts.
The codified ones.
These are the 5 types of acts explicitly listed right there in Article 288 of the TFEU.
Regulations, directives, decisions, recommendations, and opinions.
Those are the ones. They're the standard tools in the EU's legislative toolkit.
Okay, so those are the standard 5. But we know institutions adopt all sorts of other documents that aren't on that list. How do we classify those non-standard acts?
We classify the non-standard ones based on whether the treaties acknowledge their existence somewhere else. So first, you have relative non-standard acts. They're not in the big list in Article 288, but they are mentioned in other treaty provisions. Think of things like the internal rules of procedure for the Parliament or preparatory acts like a commission proposal.
I see. So they have a clear legal basis, just somewhere else in the treaties.
Correct. And that brings us to the other category, which really shows the political side of the EU.
The ones with no treaty basis at all.
Those are the absolute non-standard acts. They're not provided for anywhere in the treaties. They've just emerged out of institutional practice or political necessity.
Like what? What's an example?
Things like council conclusions after a summit, which are non-binding, or certain commission communications that outline a new strategy, or, and this is a big one, interinstitutional agreements.
Right, between the Parliament and the Council on something like the budget.
Exactly. They just fill the procedural or political gaps that the treaties didn't foresee.
That makes a lot of sense. So that's the structure. Let's move to the most practical classification for exam purposes: binding power. This is where it really matters for individuals and for member states.
This one is simpler, but you're right. It's absolutely critical. You have the binding acts, regulations, directives, and decisions. If one of these applies to you, you have to comply.
And on the other side.
The non-binding acts, recommendations and opinions.
Okay, and recommendations and opinions, they're often sort of dismissed, right?
Yeah.
Because they don't have that hard legal obligation. A recommendation is basically just a suggestion.
A call to comply with certain behavior, yes. And an opinion is really just a formal way for an institution to make its views known.
But I feel like there's a but coming.
There is. And here's the nuance that often gets tested. Even though they're not legally binding, they are not legally insignificant.
How so?
So they create an obligation for national courts to at least take them into account when they're interpreting national law or other binding union rules.
Interesting.
And they can create what are called legitimate expectations. If the commission recommends a certain action and a company follows that advice, the commission can't easily turn around and penalize that company for doing exactly what it suggested.
So they are non-binding, but they're still legally relevant. They have some weight. It's a kind of soft law.
A perfect example of soft law mechanisms, encouraging convergence without forcing compliance.
Okay, here's a little memory trick for you. Of the 5 codified acts regulations, directives, decisions, recommendations, opinions, just remember the acronym BIND-DRO.
BIND-DRO. I like that.
The first 3 letters, B-I-N-D. Those are your binding acts. Regulations, directives, decisions.
Simple as that.
Perfect.
Yeah.
So let's move on to them. The binding big 3. These are the ones that define almost all the EU law you're going to encounter. We need to know what makes them different.
Their scope, their applicability, their effects, yes.
Let's start with regulations. I've heard this called standard EU law.
It is. A regulation is the most powerful tool for integration because it has 3 key features. It's general, it's directly applicable, and it's entirely binding.
Okay, let's take those one by one. General scope.
General scope means they apply to abstract categories of recipients or situations. They're like a national law. They affect objective situations, not specific named parties.
But sometimes you see regulations that are so specific, they seem to be targeting a very limited group. Doesn't that blur the line with, say, a decision?
It can, and the Court of Justice has had to clarify this. The key case here is Zucker Fabric.
Ah, yes, the sugar factory case.
The court established that an act is a regulation if it applies to an objective situation, even if you can figure out exactly who the addressees are later. The objective situation, for example, all sugar manufacturers operating in 1992, is general in scope, even if it turned out there are only 3 of them.
Got it. Okay, scope clarified. Next up, the feature everyone knows, direct applicability.
Yes, and this is absolute. Regulations enter national law automatically, simultaneously, and uniformly across the whole union.
And no national law is needed to make it happen.
Not just not needed. Any national transposition is strictly prohibited.
Why? Why is that rule so rigid?
Because any kind of national implementation compromises the very nature of a regulation. The court made this crystal clear in the Case Commission v. Italy.
What did they say?
They ruled that any national measure that hides the EU nature of the rule or that jeopardizes its direct and uniform application is against the treaty.
So if a member state just copies a regulation into its own national law,
then citizens might mistakenly think it's a domestic law and challenge it in the wrong way or not realize they have direct EU rights. It completely undermines the whole point.
This is why we have our little memory trick for regulations. Think RULE.
RULE.
Rigidly uniform law in entirety.
Ah, very good. That captures it perfectly. It's a single uniform rule for everyone.
And because they are so powerful, they have to be transparent. This is where Article 296 TFEU comes into play.
Exactly. For any binding act, there's a duty to state reasons. The institutions have to spell out the legal and factual basis. You see this in the recitals, the whereas clauses at the start of any act.
And that's essential for judicial review.
It is. If the reasons aren't there or they're inadequate, the regulation could be annulled. That binding nature depends entirely on that transparency.
Okay, moving on to our second of the big 3, the harmonizer. Directives.
Yes, directives. These are also binding, but they work very differently. They require national action.
The structure of a directive is really all about subsidiarity, isn't it? It respects national systems more.
It does. They are binding for the member state, or say they're addressed to usually all of them, but, and this is the crucial part, they only bind the member state as to the result to be achieved.
And the member states get to choose the form and means to get to that result.
Correct. This creates what we call a biphasic regulatory structure. Phase 1, the EU sets the goal. Phase 2, the national parliament figures out how to get there.
And because of that two-step process, directives don't usually have direct effects until the member state actually adopts those national transposition measures.
That's right. And that creates the duty to transpose. This duty has to be fulfilled properly, clearly, and within the deadline, which is usually 2 years.
And just issuing some internal administrative circular isn't enough, right?
No, not at all. It's often insufficient because it lacks the publicity and legal certainty of a proper law.
So what happens during that 2-year window? Before the deadline is up, is the member state just free to do whatever it wants?
Absolutely not. And this brings us to a classic exam topic, the duty of standstill.
From the Inter-Environment Wallonie case.
The very same. The court said that even before the deadline expires, the member state has to act in good faith. It must refrain from adopting any new laws that could seriously jeopardize the result the directive is trying to achieve.
So if a directive is aiming to raise environmental standards, a country can't just pass a new law lowering them while it waits for the deadline.
Precisely. The standstill duty shows that even during that period of national flexibility, the EU requirement still puts a real constraint on the member state.
For directives, our memory trick is DIY.
Yeah.
Do-it-yourself implementation. The member state has to do the work to make it law.
I like that one too. Very practical.
Finally, we have decisions. Traditionally, these were the specific orders, often seen in things like competition law.
Yes, historically, a decision was purely an administrative act for an individual case. It would name specific addressees, a member state, or for a company getting fined.
And for those addressees, it's mandatory and directly effective as soon as they're notified.
That was the traditional view, but it's changed significantly since the Lisbon Treaty.
What changed?
Article 288 now says a decision, and I'm quoting here, if it designates addressees, it shall be binding only on those addressees.
Ah, that little word if. He's doing a lot of work there.
It's doing all the work. The implication is massive. It means decisions can now also be general in scope, with no specific addressee named at all.
Can you give an example of a general decision?
Sure. Some of the technical rules adopted by the European Council on the composition of the Parliament are decisions, or certain foreign policy measures. The Act now has a double valence. It can be specific and administrative, or it can be general and act more like a law.
So our memory trick for a decision is DOT. It can be for a designated addressee, or it can be technical and general.
A very concise way to remember the post-Lisbon change.
All right, so we've covered the acts by their effect. Let's finish up with the last classification, which is based on how they were adopted. This is their procedural status, from Articles 289 to 291.
Yes, and this is all about understanding the separation of powers within the EU. Article 289 gives us the first big split: legislative acts versus non-legislative acts.
And a legislative act is one adopted through a formal legislative procedure.
That's it. Either the ordinary legislative procedure, what we used to call co-decision, or a special legislative procedure. The key is that it involves the Parliament and the Council acting as co-legislators.
And non-legislative acts are just everything else.
Everything adopted outside of those formal tracks. And this is where we find another crucial distinction between main acts and then delegated and implementing acts.
Okay, so the main acts say a big regulation or directive sets the core legal framework. But sometimes that framework is too complex or technical to finalize every single detail in the political process.
That's exactly where delegated acts come in. This is Article 290. They allow the Commission to adopt acts of general application to supplement or amend certain non-essential elements of the main legislative act.
So the Commission is filling in technical details.
Yes, or updating an annex because of scientific progress. The key is they can only do it if the main legislative act specifically delegates that power to them, and they can't touch the essential elements of the law.
Okay, so delegated acts can actually amend the law, but only at the edges. How are implementing acts different? That's Article 291.
Implementing acts are about execution, not amendment. They're used where you need uniform conditions for applying a binding union act across all the member states.
So not changing the law, but making sure everyone applies it in the exact same way.
Exactly. Imagine a regulation on food imports requires a standardized customs form. The Commission would adopt an implementing act to create that one single form that every single member state has to use. It ensures fair and consistent application.
So delegated acts are about supplementing the law's details, and implementing acts are about ensuring consistent processes. It's that LEDI structure.
LEDI.
Legislative procedures lead to main acts, which can then be supplemented by delegated or implementing acts. It maps out the power structure.
That's a great way to put it. So to pull all of this together for your exam preparation.
Let's do a quick recap.
First, remember the hierarchy. Secondary law is always subordinate to primary law, and it's always constrained by the principle of conferral.
Then, the big three binding acts.
Regulations are uniformly applicable, and you must remember that national transposition is prohibited. Directives mandate a result but allow national choice, and they impose that duty of standstill.
And decisions can now be general in scope, not just for specific addressees.
And finally, don't forget the procedural distinctions. Legislative versus non-legislative. And within non-legislative, the difference between delegated acts that supplement and implementing acts that execute.
And we should mention one more time that the legal validity of every single one of these binding acts relies on that essential procedural requirement we talked about, the mandatory duty to state reasons under Article 296.
Yes. That requirement to justify the act is the ultimate safeguard. It allows for transparency and judicial control.
Which brings us to our final thought.
Indeed. We've defined all these types of acts, but here is something for you to chew on as you study to take this knowledge into a more critical space.
If that detailed justification, the recitals, the whereas clauses, is the entire foundation for judicial review,
how might the political goals or the messy compromises reached during the legislative process be subtly obscured or maybe even unintentionally exposed by the level of detail the institutions choose to provide in their official statement of reasons?
It really makes you look at every whereas clause with a bit of suspicion. Thanks for joining us on this deep dive into EU secondary law.
Good luck with your studies.